we have had the illustration. From that illustration, let us try to understand the concept of conflict and dispute. Here are two friends, classmates. They are in good relationship. The friend who wanted help approaches his other friend, and as a matter of gratitude, as a mark of gratitude, he offers him the first floor as a temporary arrangement. There is no legal formal agreement entered into between the parties. He occupies the first floor with his family. There is no understanding of landlord and tenant. There is no fiduciary relationship of a landlord and tenant. The wives also get along well. They also start a business which is not legal. However, they flourish. After few months, due to probably mismanagement and also COVID-19 situation, they start suffering loss, resulting to misunderstanding, difference, disagreement between the two ladies. The third parties, the subscribers to the chit, they all start interfering. There will be more animosity, blame game, followed by the repercussion affecting the relationship between the two friends. Now, what has been lodged by the landlord before the court is for recovery of the arrears of rent and eviction of the tenant from the premises. This we call it as a dispute. He feels that his rights have been infringed. He, as a landlord, approaches the court, lodging his dispute for recovery of arrears of rent and for eviction of the tenant. It is not just as simple as that. What has led him to lodge that complaint or the dispute before the appropriate civil forum is the mismanaged chit fund between the two ladies, which is running into several lakhs. Now that there has been a chit transaction and there has been a mismanagement, each one blaming the other for the mismanagement, and through the mismanagement there is a financial suffering is not in doubt. Now this cannot be addressed in the court. They cannot approach, the two ladies cannot approach the court asking for a order, a finding, an adjudication or a judgment on this, because the very chit transaction is not legal. But that is the cause for the animosity which has led the husbands to go to the court and try to find a solution through the dispute. Now, dispute, that is to say, even if the landlord wins the dispute, where he gets the money, as also the eviction of the tenant from the premises, is not going to end the conflict. The conflict being the larger one, namely the suffering they have had, the financial suffering they had in the chit transaction. Please appreciate that in the dispute there are only two parties, namely the friends, the male friends. Whereas in the chit transaction, which I call it as conflict, there are more people, namely the husband, wife, landlord and tenant, and also the entire family members, and the stakes in the conflict is high. If the dispute is resolved, it is not an end to the conflict. If a conflict is resolved, It's an end to the conflict as also the dispute. When the mediation takes place, the mediator, though he starts the matter with a understanding of the dispute, realizes at a point of time that the dispute is only a fraction of the conflict. Both parties are not looking at resolution of the dispute only. They need to resolve the conflict. They have to manage the conflict. Therefore, addressing of the dispute is not going to give them the relief, then permanent relief. Even if the case is allowed, granting eviction and arrears of rent, the landlord is not happy. If the case is dismissed and the court says that the tenant need not be evicted or he need not pay rent for whatever be the reasons given on the merit, the tenant is not happy because on their head there is a sword, namely that failed chit transaction which has caused animosity between the entire family members. So the mediator understands that there is a dispute, but both parties have something very serious in the form of a conflict. Unless the conflict is addressed, dispute will not be addressed. Even if the dispute is addressed, the conflict will remain. So, the mediator diagnoses that the conflict is different and the dispute is different. The parties, through the dispute, they are shooting to find the conflict and solve the conflict. Therefore, the mediator has to address, maybe by involving the entire family members, and try to find a solution to the conflict which would not only end the conflict, it will also end the dispute. This is why we have to understand two things here, that conflict is there, therefore a dispute is there. Conflict is larger than the dispute. Conflict manifests dispute. We can also understand by this example now. Here, the man has headache, persistent headache. He gets the necessary treatment, but he is not able to find the solution. He approaches the doctor, takes the necessary medication. He is not able to come out of the headache. He also changes the medication, takes a stronger dose, but still is not able to find the solution to the headache. The headache persists. After some time, the doctor, after understanding the patient fully, he says that the patient is also having something more, namely acidity. And he learns that his headache is because of the acidity. Now, headache cannot be easily solved because the treatment taken by him is for the headache. When he realizes that it is the acidity which is causing the headache, he treats himself for the acidity. When the acidity is addressed, headache is also addressed. When the headache is tried to be addressed, headache is resolved or not resolved because acidity still persists. So it is a similar case here. So acidity is the cause, acidity is the conflict, headache is the dispute. I think this can be a better explanation to understand. Why this is required is the mediator has to understand these two scenarios to understand as to where does he focus his mediation, to the dispute or to the conflict. Now, we'll try to understand some of the conflict management styles adopted by the parties. It is called as a competing style, where one says, I win, you lose, or I'm right, you're wrong. This is usually used by a person who always thinks this is right. He wants a quick decision and he has no time. He doesn't want to apply his mind and see what would be the matter running in the mind of the opposite party. He always wants to highlight his rights, focus on his rights, and therefore tries to find by saying, no, I am right, because I know I am right. You are wrong, because I am right. He has no regard for future relationship. He is here to win by saying, I want to end this relationship, I want to end this my way. This is called as competing style. Accommodating style. Here, it is the opposite of the earlier one. I lose, you win. I'll give up, you take. Probably because for me, this is not very important. It may be important for my opposite side. So let him take it. Or it could be that, or because my case is weak, so therefore I do not want to canvass it. Or it could be for a time factor or some such situation where he feels, okay, this is not the right time for me to fight. I want to somehow get rid of this. I don't mind losing this. If it satisfies him, I don't mind giving up my right over it. Probably it is also because he feels that the relationship is more important than winning this argument. I might be winning this negotiation, but that is temporary. But I may lose the relationship, which is permanent. Therefore, I would like to give up, make my opposite party happy if it saves my relationship. The next one is avoiding styles. It is very simple. I am not going to be a winner, but I am not going to be a loser too. It could be a situation where he is not prepared to handle, or again, it's a time factor, he doesn't have the time. He simply says, no, I have no time for all this, I have no chance of meeting this, let us not get into it. We will continue to have this conflict. We will avoid this conflict. Or it could be because stakes are not very high. Okay, the stakes is only rent of rupees 3,500 rupees, as we had seen in the earlier illustration of the landlord and tenant. So into 40 months, okay, it is 1,20,000. So the tenant may say, I would prefer to lose, give up that 1,20,000, because if I get into the issue of cheat, then it could be a serious loss. So I don't mind losing the dispute, because I can still save the conflict and have some revenge against him in another form, in another platform. Compromising style. I will win some, you win the remaining. I will lose some, you also lose. So let us both be parties to the loss. Collaborating. I win, you win. Let us both win. Each identifies the underlying concerns of both the parties. Each one of them try to understand the perception of both the parties. Each tries to find as to what could be the best solution to the opposite side. Both try to see what is win-win for both. One feels that better solution can be achieved by working together than working alone. It is true in mediation. When the parties adopt to collaborating, they start working towards a solution. It will be a team effort where both try to get what each one of them is trying. they start developing greater level of trust, confidence, and they see eye to eye. When the mediation begins, they will not be seeing eye to eye, but slowly through the process of mediation, with the intervention of the mediator, they start talking to each other, having eye contact, and rebuilding their communication. They understand that the best decision can also be made by having a collaborative style. We have had the conflict management styles. Now we will deal with the defense mechanism used by the parties. Denial. They do not want to accept there is a conflict. They are always in the denial mode. Again, avoidance. Avoiding to get into the conflict. Remain in the dispute. Do not traverse beyond the dispute, because if they get into the conflict, it could be a larger issue which they probably are not wanting and they want to avoid. Projection. It is very interesting. Highlighting the demerits of the opposite side, highlighting the merits of his side. Both parties try to highlight each other's merits and demerits and take the merits to the advantage, demerits to the opposite party. They start reacting. It is called as tit for tat. I will not give you because you did not give me something. There is an example which is on the screen. Please see it. There could be any number of such instances where they try to find a solution by saying, you did not do it, therefore I am not doing it. You said this, therefore I am saying this. Had you not said, I would also not said this. Because you said, I have said this. So it's a tit for tat. Displacement. The narration itself is an explanation. Escalation. Blowing a small issue out of proportion. Trying to get the attention of the entire surrounding, people, relatives. Trying to exaggerate it. Get into the notice of all. Drawing the attention of everybody and saying that this has led me to this situation. So far we have tried to understand in this chapter. There are disputes, there are conflicts. Conflicts are hidden, probably intangible, not easily identifiable. Dispute is manifested out of the conflict. Very rarely we see a dispute without a conflict. There are styles which are adopted by the parties. There are methods adopted by the parties. There are styles adopted by the parties, and those styles have been also understood. This is relevant because as a mediator, the mediator has to look into the perspective of each of the party, whether they are looking at a short-term solution or a permanent solution, whether a short-term solution is an answer when a permanent solution is not got, and when a permanent solution is answered or addressed, whether it could be also resolving the entire gamut of conflict and the surrounding issues. A wholesome settlement against a part settlement. A wholesome comprehensive result as against a temporary result or a short-term result. Thank you.